Good evening, everyone. I'm calling the special called meeting, the Board of Supervisors, Wednesday, August 3rd, to order. If everyone would please rise for the Pledge of Allegiance and a moment of silence. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Moment of silence, please. Thank you. All right, moving right into the review of the Berkley Group Land Use Policy Evaluation.
Okay, good evening, Board of Supervisors members. Thank you so much for having us here tonight. It's such a pleasure to be with you tonight, and I was regaling with my coworker Rebecca here about how beautiful of a drive it was up through your county. So it's fantastic to finally be in Rappahannock County. For those of you that don't know, my name is Chris Musa. I'm with the Berkley Group. We're a consulting group for the local governments throughout the Commonwealth of Virginia. I'm joined tonight by my associate Rebecca Cobb. And for the last 6 months or so, we've been working on a diagnostic of your zoning and subdivision ordinance, and we'll dive into exactly what that entailed in a second here. So we can do the next slide if you don't mind. Sure. So just a quick agenda of what we're going to go over tonight. We're going to review what the intent of our project, of our diagnostic was. We're going to check the overview and what the schedule looked like. Talk about the purpose and the content of the ordinance, the comprehensive plan policies, the diagnostic review, and then for the most part tonight, we're going to hear from you guys. That's really what we're here to do tonight, is have a discussion and answer any questions that you have. So really quickly, we'll talk about the intent. This is just a quick overview of why we went into your zoning ordinance. First and foremost, we wanted to make sure that your zoning and subdivision ordinance complied with the Code of Virginia, as well as best practices that we've seen throughout the Commonwealth. We wanted to identify any issues that we saw with organization, modernization, and any issues that staff and board members, such as the planning commission members, I should say, had identified to us. We want to ensure that your ordinance wasn't just regulating properly, but it's also easy to administer for county staff. And we want to highlight any additional changes to allow for easier administration that we found. All right, this was just a quick overview of the schedule. So we started with a kickoff with your staff members. They gave us any issues that they were having and any advice that we should be looking out for. We did the same with your planning commission with the work session number 1. Then we started going into your ordinances. We started digging through and checking that against the Code of Virginia and any best practices that we had. We created a report, which you had in front of you tonight. We met with your planning commission, and they gave us their feedback on the report, and here we are tonight to get your feedback. So really quickly, for those that don't know what a zoning ordinance is, basically a comprehensive plan lays out the vision of your community. It's a policy document meant to guide policy. It's not law. What is law is zoning and subdivision ordinances. Zoning ordinances are not required by the Commonwealth of Virginia, but they are strongly recommended, and they regulate everything that's kind of listed there. They're land use laws. This is all here to regulate land use throughout your county. Subdivision ordinance is required, and it's just the same thing. It's all about the division of land throughout your county, whereas zoning ordinance is more about the use of that land. Next slide. So these were some of the principles from your comprehensive plan that we pulled out. And then these are like the potential zoning elements that go with it. We did a review of your comprehensive plan's goals, principles, policies to identify where your ordinances are strong and weak in supporting them. The complete report of our findings, it's in Appendix C, but it's not exhaustive. We looked at what we thought was most pertinent from your comprehensive plan to your zoning ordinance. And these are just a couple of examples here on the slide, which I won't read through for you. I won't have to bore you like that. If you want to go down to slide 8, we'll dive into this diagnostic review.
And I do have, the presentation is on board docs, I believe, so.
Perfect. So if you want to read through them, more than that's all in your report as well. Like I said, it's a
Can I ask a question?
Sure, absolutely.
Do you want to work through everything first, or do you want to take questions as you go?
I think the easiest way to do it is if I work through my presentation first, and then we'll do a discussion at the end. But if you have a quick question that you need me to address right away, that'd be fine.
Well, I just wonder in the previous slide.
Sure.
There you go. You say encourage residential development within the designated village areas.
Right.
How are you determining what a designated village area is?
So
Because we don't have maps.
So
as
that's
you
based
probably
on
have heard.
yeah, that's based on your zoning districts, your residential zoning districts.
Okay.
And that's a quote out of our
Comprehensive plan.
right?
Yes.
Right.
Yes. Yep. Yep. So that's just what backs up that policy within the comprehensive plan. The plan is asking for encourage development in residential areas. Your zoning portion of that is, hey, we've designated these zones as residential zoning districts. So that's what we would consider residential areas. Does that make sense?
Yeah.
Perfect. Okay, we'll move on. So our matrix kind of breaks down all the different sections of State Code of Virginia, sections that apply to zoning and subdivision. And there are some of them that aren't quite applicable to Rappahannock County. The chart on the left there tells you which Code of Virginia codes are applicable, or how many are applicable and how many are not. About 80% were applicable to Rappahannock County. From that, the charts in the middle, those are the ones that you comply with. About 34% of your zoning ordinance complied, and then 26% of your subdivision ordinance complied. And then there's a gray portion of that are optional provisions. Code of Virginia doesn't require you to have them, but they are optional provisions. And then that third graph right there shows you how many of those optional provisions you are in compliance with and how many you are not.
As I imagine it's a continuum of compliance. It might be completely missing from the zoning ordinance, it should be there, or we might have something that's similar to what's required, it's just not exactly aligned.
Correct. And we kind of, I don't want to say did our best guess, but we made our interpretation or our recommendation on whether or not you were in compliance or not. And any of those that were kind of on the fence, we did a partial there. So you see there's a 7% partial for your zoning ordinance and a 13% partial for your subdivision ordinance. That's where you're kind of in compliance, but it should be better, and you could do a better job about it.
And your appendix runs through these exhaustively.
Yes, sir. That's Appendix A for the zoning ordinance and Appendix B for the subdivision ordinance, I believe. And those will list each section of the Code of Virginia line by line and tell you, yes, you're in compliance, you're partially in compliance, etc. Yep. So these were just kind of our overall general findings about your zoning ordinance. We did find quite a few things that we thought needed to be updated to comply with the Code of Virginia. Another major thing is that the state legislature is always meeting and always adding things that they want localities to do throughout the Commonwealth. So it's important to go back through and check every year, is what we recommend, an annual review, to make sure that anything new that comes out of the state legislature is being incorporated in your zoning ordinance. Another thing I wanted to bring up was the organization of your zoning ordinance. It was a little difficult to get through. We have a very specific way that we like to present our zoning ordinances that makes them easy to read and makes them easy to administer, and that's found in your report there. I can get you a page if you want it. But basically just reorganizing those articles in a more easy to follow format for your staff and any lay individuals, citizens of the county. Consideration of adopting additional provisions to come in line with more modern standards and best practices, incorporating additional clarified provisions, consolidating uses, all the different land uses, into more modern uses or broader categories to make it, again, easier to administer and modernize and streamline uses. And again, this all gets broken out more in detail in the report, which you can read through. I'll go into a bit more detail here about some of the things I'm just pulling out that we thought were highlights. At the moment, you as the Board of Supervisors are handling special exception permits, and the Board of Zoning Appeals is handling special use permits. And we've heard from staff and the Planning Commission that this can cause some issues, and it's got a little bit confusing, and it's kind of gotten away from its original intent and purpose for that division. So we've asked that you go back and readdress that and make sure that that process is still in line with what you like, and see if you can try and make that process a bit more streamlined for citizens throughout the county. Adding process details for conditional zoning and proffers. The use matrix, moving and reorganizing the current use matrix. I won't dive into all of this, but you can get into it in the report. Reorganizing and improving use standards. Your use standards right now, they're integrated into different articles throughout and this comes back to the organization, throughout your zoning ordinance, when they should really have their own article. So that's kind of what I mean by reorganize and improve use standards. And then the rest of these we won't touch. If you want to do the next slide, we'll talk about these ones really quick. Accessory uses should be clearly defined, moving them into the use matrix instead of having them in their own individual articles. Home occupation should be clearly defined with associated standards. A lot of these came from staff issues and planning commission issues that were brought up. Group home, this was something that we found that was out of compliance with the Commonwealth of Virginia State Code that needed to be addressed. Same with telecommunications. This needs to be updated to address state code. And solar facilities, this is kind of just a best use. Solar is becoming a thing here in Virginia, and it needs to be addressed in every locality zoning ordinance. So we recommend that you separate that use from the renewable energy generating plant and have it as its own separate use with its own use standards, and you can give provisions and regulations to solar use as you see fit. And then lastly, lighting, noise, signs. These are all things that we can go back through and further enhance the regulations. Lighting can be brought up to International Dark Sky Association standards to better serve your community and keep things rural around here. Noise regulations are included in the zoning ordinance when most localities throughout the Commonwealth, they kind of have those as a separate chapter in their locality's code. And we recommend doing that, and that'll give you a bit more regulation as far as regulating noise throughout the county.
And one of the things we talked about at the planning commission level is for agritourism uses, we can only regulate noise at those uses to the extent that we regulate noise for other uses.
Correct.
And without a noise ordinance, you lose that
Correct.
opportunity.
Yes, sir. Yeah, and so that's kind of where our head was at in pulling that out of the zoning ordinance and putting it as its own chapter in the county code.
I don't mean to interrupt
No,
again,
of
but
course.
do you feel like you have direction to work on lighting and noise?
As far as if we needed to go about doing it now to make those
I
changes.
I think those are some pretty substantive changes that a lot of people would have issue with.
Absolutely, and we would want to go through obviously the public process and kind of have our own updating process if we were going to do that. It wouldn't be just a quick fix at all. I don't think any of these are quick and easy fixes.
These are items you
unfortunately.
bring to the board's attention for them to consider whether they're items they want to tackle
Correct.
Yeah.
or not.
Yes.
Well,
yeah.
I'll just say, and again, I don't want to get too far afield,
No.
but we love and encourage international dark sky standards.
Yes.
However, I personally think a carrot approach is a lot more successful than a stick.
Sure.
But I guess that's part of a bigger. I just want to know, it sounds like you're considering these. You don't feel like you have direction.
No, these are just our recommendations to you. This is from feedback that we've heard from staff and planning commission and how we, and your comprehensive plan and how you want your community to look and your vision. This is what we recommend that you do to achieve that vision. So Rappahannock County prides itself on being a rural county and being beautiful and being beautiful at night as well. So you want to adapt your lighting standards to continue that beauty, to keep things rural, and so that people can see the skies at night. So that's what we recommend, is just to make sure that you bring those lighting standards up to International Dark Sky Association compliance to achieve that. Does that make sense? Sorry, does that answer your question?
It makes perfect sense. I guess I sort of wish we'd had a joint meeting earlier so we all could have had input on this, because I feel like this is kind of news to us.
Okay.
Or
And
we haven't had an opportunity for input on this. And these are substantive directional changes.
Yeah, for the record, Rebecca Cobb with Berkley Group. This is just a diagnostic. This is saying we have reviewed your ordinance and these are the things that we're seeing. These are the things that we think you should consider. These are not things that, I mean, you all haven't given us permission to go in and start making changes to your ordinance.
Okay.
This is not, you know,
Well,
making changes to your
I'm-
ordinance at this point.
And I just wanted to know, you know, kind of where these things are coming from.
This is just identification. This is step one upon any change to any sort of ordinance that we would do. Step one is find out what the problems are and see if we can find any solutions. This is kind of our recommended solution, but we're not going to make that change until we get input from both planning commission, from the public, from the board. Obviously, we're not making any changes right now at all. This is just the identification.
You need input from the board, not the public, as much as the board.
What's that? I'm sorry.
You will need input from this board more than you need input from the public, because this board is elected to represent the public.
Correct.
And all too often here recently, and I say recently, the last couple of years, maybe as many as 5, we have self-appointed groups that bind together and try to influence public sentiment and public policy. And we already have that body.
Sure.
This is that body.
Yeah,
So
and
if you're listening to anybody else, I would caution you to.
No, sir, no.
quit doing
I only mentioned the public because any sort of amendment or ordinance change that you make to your ordinances does have to go through a public review process. So you would have to have a public hearing.
Public hearings.
That's all I meant by
We
that.
hear
It's
from
just
the public, but we don't
Sure.
want to have little splinter groups influencing
Sure.
what work you put out.
Sure. No, and again, this is just first steps. We're not changing anything right now. We're just coming to you to show you this is what we found, this is what we recommend you do, and then we leave it up to you from there. This is your time to give me that feedback, that input that you have. And of course, we'll take that input for as long as you'd like to give it to us, basically.
Yeah, I imagine there'll be, at some point, a prioritized list of items that the board thinks the planning commission should be working on, coming out of this process. And lighting and noise could potentially be on that prioritized list somewhere, likely to be very low on the list, if it's on the list. But other things that the board's talked about recently, like the legislative acts and the BZA, those might be higher on the list. And the planning commission, with assistance from Berkley Group, can begin to tear into that and try to make some of those changes. But that was to be directed by the board, and then a scope would have to be developed and
Sure.
authorized and approved to start going down that.
Absolutely, yeah. All right, we can move on to the subdivision ordinance next. And I'll try and keep things brief so we can keep our discussion going. Overall, the general findings in the subdivision ordinance were good. They were mostly in compliance. We recommended that you also reorganize plat requirements, timelines, administrative elements into themed sections. Another big thing on organization is we're starting to recommend as a best practice that everyone, that localities take their subdivision ordinances and move them into their zoning ordinances. This kind of creates a land use regulation handbook, if you will, makes it easier and more streamlined just to find everything. Zoning and subdivisions go hand in hand. So having them all in one location for your administrators, for your county staff, and for your lay citizens, it just makes things a lot easier. Strength, and we found that roughly 13% of the Code of Virginia subdivision regulations, you were only in partial compliance with 13% of them, which could be easily fixed. And then requiring phase 1 environmental assessment and remediation disclaimers for all previous industrial. This was just something that came up in the Code of Virginia, and we recommend that to keep things nice and environmentally friendly around here. You can go ahead and hit next slide. All right, again, just kind of pulled out some stuff that we can talk about here. Your current ordinance requires preliminary plat for all size subdivisions, but Code of Virginia only requires preliminary plats for 50 lots or more. So if they're doing any subdivision for less than 50 lots, they do not need to provide you with a preliminary plat per the Code of Virginia. Expanding cluster subdivision provisions. You have cluster subdivisions at the moment, provisions for them at least. And we just recommend kind of expanding upon them just because they're a good way to preserve open space and keep things rural. Update bonding requirements. Similar to before, allow for partial release of performance bond. And then outline instances when the zoning administrator can approve administratively plat reviews. So like single lot subdivisions, family subdivisions, and boundary line adjustments, those can all be easily approved by any zoning administrator, and that's how most localities throughout the state are doing it.
They already are, aren't
And
they?
we do that with, I guess, 3-lot subdivisions now. It's not clear in the ordinance, and also ordinance, if a lot's bigger than 50 acres, then it's just considered not a subdivision at all. You can have 1,050 acre lots and it's just do what you want, which seems crazy to me.
So we can get into the next steps. So these are just some of the next steps that we laid out, and these are all in your report there at the end. We recommend a complete and comprehensive zoning ordinance and subdivision ordinance in line with the recommendations that we've given. We were just discussing how we go about what to do next, what changes we want to make, what's high priority, what's low priority. In my opinion, when it comes to anything law, especially ordinances, zoning ordinances, land use, consistency is key. So doing everything now, everything that you want to do, would be ideal. I understand that that's not always feasible, but that's the recommendation that we're going to give. Amending specific sections of the ordinance as applicable per this diagnostic. These are some of the things that you could do if you don't want to do a full-fledged ordinance update. And developing overlay districts in accordance with the comprehensive plan, such as Mountain Ridge overlay districts, and I think there was an ag forestal district. I'd have to double check on that one. And then update zoning to align with comprehensive plan. Again, just updating it to make sure it's in compliance with Code of Virginia and your comprehensive plan. And then the next slide is discussion, which I'm sure this is what we're all wanting to get to. So I will stop talking so that you can all start talking.
You're a fast talker, so
Sorry about that.
Yeah.
it's okay. So am I usually. I have to focus on trying to talk slower.
I know nobody wants to listen to me, so if I do it fast, it'll be over quicker.
But I hear slowly, so that's the problem.
Oh no, sorry. Well, I can go over anything that you missed and try and clarify things for you if you'd like.
Maybe if the board will allow me to say a couple things, and Ms. Summers and I think that I'll put this next steps part up, the application process procedures. The board touched on that with a recent modification to 170-55 for the application for SOPs and SEs. And what happens at the planning commission and the board, and when there's a public hearing, when there's not.
Yeah.
That whole process, I think, needs continued review to ensure defensibility down the line. You've seen some cases where you've had some special exceptions be appealed and go to court, and still haven't received an order from the judge. And so if we can improve those processes and strengthen them and best align them with what the Code of Virginia allows us to do, I think it allows it to be more defensible down the line. That's one big thing. Another significant recommendation that they made was related to these, how did you call it, the use regulations. And right now, all of the specific use regulations for all the special exceptions, special use permits, I think is Article 6. And, a particular use has all kinds of specifics, like you can only have X number of people and the road has to meet this standard and all those things. But if in your use table, there's a P in that table and is permitted by right, none of those use standards apply. And it's really peculiar that we need all those particular standards if it's a special use, but we don't if it's by right. And their recommendation is to turn the ordinance around a little bit and have those use requirements for all your uses, whether they're a special exception or a special use permit. There might be some different standards that apply to an SE or SUP because of how it fits into the community, but I think that's another big structural change that would be
And I can touch
very
on
good.
both of those if
Yeah.
you'd like me to. I know we didn't touch on permitting processes, but at the moment, your permitting process is like a pre-application approval by the planning
We
commission.
just changed that so
Okay.
that now if the.
And that was our recommendation.
And that was since you've been working on this.
Gotcha.
And, basically, if you submit a complete application 16 days or more before the planning commission meeting, it lands on the planning commission as a public hearing, bang.
Perfect.
It's already done, out the chute, public hearing. And then, the planning commission will refer it on to the, whichever deciding board it is, who then is subject to have a public hearing at some point in time within the regulated, period of time.
And so we would just recommend to make sure that any application requirements for that application are clearly listed within your ordinance in the permitting process.
Which is not very well laid out now in our use table. It has a check for site plan, but site plans, have this huge connotation in the zoning ordinance of what it includes, where it might not be needed that early in the zoning process. So I think that whole thing needs to be cleaned up.
Yep. And as you touched on, uses, if you have use regulations attached to a by right use, those are basically just rules that apply to that by right use no matter what. So let's say if you allow gas stations in residential districts, but they have to be less than 500 square feet. Anybody that comes in and tries to do a gas station more than 500 square feet, you can deny that outright, or you can cite them for a zoning violation. This is just to make things more streamlined. So you don't have to go through the special exception process every single time. If you're seeing the same thing over and over again and you're putting the same conditions on the same special exception over and over and over again, you should just turn it into a by right use and take those conditions and make those use regulations for that by right use. So then those rules are applied to those special exceptions all the time. If that's not something you want to do and you want to keep a special exception, you can still have those use regulations that apply to that special exception, and then any additional conditions you want to put onto it, you'll put on that special exception permit.
Similarly,
sense?
I would say a gas station in a commercial general area, which is allowed by right, but there aren't necessarily any specific requirements for that use. But it might make sense to say, yes, we want gas stations in general commercial. However, we want them to meet these minimum standards. Because these minimum standards are, fit the Rappahannock County vision. Whereas right now, it's just, as long as you meet the general requirements of the zoning ordinance, you pretty much have to let them build their gas station.
Great. I can field any other questions that you might have, any discussion. I can step back and let you talk.
I guess because, maybe because it's a little more dear to my heart than others because of certain letters that we received a year or so ago, but what's wrong with our solar generating facility regulations right now?
So right now, the use is a renewable energy generation facilities. That's the term that you're applying to, that a zoning administrator would have to consider a solar facility to be. They would interpret a solar facility to be a renewable energy generating facility, because that's the use that you allow for in your ordinance at the moment. That use doesn't, not to my knowledge, and it's been a couple months, but it does not have any regulations associated with it.
Oh, no, it has some.
It does have some, okay. We would still recommend you take that solar and make it its own individual category. There are different levels of intensity of solar, such as rooftop solar or small solar, if somebody wants to do like a line of
We're
6
not
solar.
regulating the small scale, we're doing utility scale.
Sure, and so you would have those different levels because the regulations would be different compared to a 300-acre solar farm compared to somebody that puts a line of solar panels in their backyard. You would want different regulations for those two different intensities. Does that make sense?
Where there is some awkward, where it is awkward a bit in our ordinance now, and maybe this is fine for the board based on how it's laid out, is that a wind generating, wind power, whatever you want to call these,
Yeah.
say wind generation facility, but it doesn't generate wind, so it doesn't sound right. But,
Wind harnessing.
wind harnessing, yeah.
Yeah, there we go.
Yeah.
That's the ticket.
That's in the same, that's governed by the same sections of your zoning ordinance, and really have different metrics that you might want to look at. Right now, it's cast in the same view, and you'd have to meet the same acreage requirements. The end may, the means may justify the end, I guess, backwards, but it's pretty difficult to permit either one of those in the county right now.
Sure.
But there might be a special circumstance that it might happen. But if that's where the board wants to be,
I think
maybe not high on your
And we're
priority.
not recommending that you make solar by right everywhere in your county. You can change it how you want, but we're preparing for the best case scenario here, right? You want to make sure that you have the regulations in place rather than not have them.
We
if that
want to
makes
make it
sense.
very difficult.
That's fine.
But
That's
not
your intent, yeah.
exclusionary.
And we need,
Sure.
and we do permit by right, that kind of accessory solar use for a home, and that happens, or a business.
Yeah. Our recommendation was just simply separating the two uses so that you can regulate solar one way, wind another way, or hydro, or whatever the other ones
On
are.
the mighty Thornton River.
Well, a future board may have to get into impoundment, and then a generating facility may make sense.
Well, and we think about these things, we have some elevation here, and renewable energy and elevation stored water is a future energy storage sort of thing, and, could somebody slip that in through this ordinance? You put a big tank or a pond on the top of the mountain, and you pump the water up during the night when the power's cheap, and you flow it back down through generators during the day. People could try to slip things through our ordinance based on the way it's worded, but if it were specific solar and wind, then you probably could slip through that same sort of thing, and that didn't even come to my mind when we were putting that together.
But it did now.
But it did now.
As long as it's all Yuma green, it'll be okay, right?
Yeah, that's right. Nobody'll see anything. It's not very loud.
Well, and I guess I think of the list of items we'd referred to the planning commission. Could we pull that up and make sure everything's captured?
Possibly.
And to me, I guess that's where I would have thought the priority would have come from, is the items that the Board of Supervisors had previously referred to the planning commission.
Stand by.
Please hold.
This, I don't think they address signs at all.
I think it was in the last
Well,
slide or one
When
of the slides.
we were working on the scope, there was some thought that we might try to throw in supportive sign ordinance changes at the same time, but then the planning commission was working on it. I think that's one of the first things that after the planning commission finishes their work, then we can have a review of best practice with that. But the timing was messed up with signs because of all the work that's been going on. I don't know why that didn't come up.
Maybe this is just a trick to get it over the finish line since it's been going on since March of 2020.
Sure. We're gonna get there. All right. So sign ordinance, several of these are done. Public art is sign ordinance. There was a question about professional office, and that was related to your highway corridor district that
It's
for
sort of
whatever
resolved
reason,
itself.
doesn't allow professional office, even though you have a fair amount of professional office there. Family subdivisions is one, which I think there was some mention of within the subdivision ordinance.
Yeah, there was a language about changing the definition of family. I don't know where that came from.
Is that to align with state code possibly?
It might have been. I would have to.
Code has recently, sorry, Chris.
No,
State code
please.
Has recently broadened and allows localities to broaden the definition of family if they want to. So we're just kind of bringing your attention to it that you could consider that. You don't have to change your definition of family, but you could broaden it if that's something that you want to do.
Temporary structures, I think that was, temporary and accessory structures, I think that was linked partially to the Old Hollow property. And
Yes.
do we want to get into a more structured regulation of accessory structures? Right now, basically, you can have as many accessory structures as you want on your property. You can have 35 sheds as long as you meet the yard requirements. Do we want that? Events, this whole continuum of events, that is another big area that the planning commission knows is down the line, and one that I think they've talked about wanting to work on, and I've told the board before, in some cases, for some of these things, we can trade money for time and get support from a company like yours to help us push through some of these the development process for these ordinances to get them live in front of the planning commission, let them chew on them, maybe push them back and forth before they eventually get before the public to see some options for them. But we have conference center resort, the difference is whether you have people staying overnight, very confusing, basically the same words, only they're two different uses, permitted different ways. We have country inns, we have bed and breakfast, we have tourist homes. So all of these things, and then we just have field parties and other shows and carnivals, and that whole thing is very confusing, whether you're a nonprofit or you're not a nonprofit. That's a big part that needs to be looked at.
Well, and then the thing I hear from folks is that really, certainly we shouldn't prohibit events from pairing with nonprofits and vice versa, but it shouldn't be there should be a limitation on the number of times per property that a nonprofit event maybe could happen per year, maybe 3 or 4 times a year.
And this is another area where if you had use standards tied to that use, then you could have this whole list of things that you must comply with, whether it's sanitation or entrance or this or that, even if it's by right. You know, a nonprofit to have an event is a good thing, but you should be able to get in and out and have a toilet and all those things.
Right.
The family apartment was changed out to accessory dwelling units, so that's done. The short towers, there was an insertion to allow shorter than what are the portion in the state code that allows administrative reviewable projects. But this is even a more streamlined process for really short towers. Events added on to the nonprofit, and vehicle access to events, which was a very recent referral to the planning commission. And the concept there is that events in general, to include agritourism events, might draw a number of vehicles to an event. Some of these venues have narrow access routes, and if there was some sort of incident, those vehicles would probably be exiting the site at the same time first responders need to get in. And particularly for agritourism events, the Code of Virginia does allow us to regulate on public health and safety.
Correct.
So thinking that we might be able to place some regulations to require minimum standards for entrance from a public health and safety standpoint based on numbers of cars, and that's before the planning commission right now to chew on.
Yeah.
But these are all little one-off things that I think need to fit into some of the bigger concepts that you brought forward that would really help our process.
Sure, and it sounds like a lot of the issues are coming from use permissions and use standards, which is definitely something that I would recommend we could tackle all at one time. Bringing up a brand new use matrix, making a use crosswalk, and kind of combining your uses into better, broader terms and more modernized terms, and then attaching new use regulations onto them as you see fit.
The one thing that's not on this list because it wasn't referred to the planning commission is a task placed upon the county attorney and myself, and I guess Ms. Summers by extension, is to review the use table SE, SUP, and P, and that is core to some of your recommendations for
Absolutely.
reevaluating that table to see is what we're doing right now the
Perfect.
best way to do it.
Excellent. Good to hear.
And the board did provide some budget for us to advance a lot of this work with the planning commission in this current fiscal year. And that, therefore it is, while it's difficult to springboard from this discussion, from staff's perspective, we do need to understand what does the board think about what types of changes you want us to begin looking at with the assistance of Berkley Group and the planning commission to, are we just going to chisel away at these small little pieces, or do we really want to go after it and restructure things, take the zoning ordinance and the subdivision ordinance and put them together and do all that? We can probably take either approach.
Sure, and we are available for you if you have any questions. You know, my recommendation is to chew on it. take this report home, read it, and really think about it and come up with a list of things that any questions that you might have or strategies that you may want to approach. And feel free to just reach out to us and contact us, and we'd be happy to talk with you again if that's something you'd want to do, or answer any questions via email or however.
And we can tailor things in terms of timeframes. If, if we have this much money, then we can say, okay, we can do this for you with that much money. And then you can, look at that and we can prioritize and shift things however you need to do.
It's little doubt that our staff isn't that large, so
Right.
And you're busy doing other things.
we're working on that.
Yeah.
But,
And this is a lot of information to process. We understand that.
Well, and these are big push issues. It isn't
Absolutely.
like something we want to hire staff to work through this, and then we get through it, and then we have staff that
exactly.
doesn't have tasks coming up because, the work has been done.
Correct.
So in an instance like this, it certainly does make sense for us to team with somebody like you all to get the work through, and we sure do appreciate
The
you.
last major rewrite of the zoning ordinance was in 1986. So if we get
That was a
it,
good year.
if we nail it down now, then, we'll look at it again in, 30 or 40 years. When I say we, it'd be
Sure.
not me, we.
The one before that was 73.
73.
66, so
So we're extending each time, so it'd probably be like 2200 before we get to it again if we do it now.
yeah, it might be about right.
I have a very specific question.
So I'll try to answer to the best of my ability.
In Appendix A, there's VA State Code Section 2288. Localities may not require special exception permits for certain agricultural activities. And it seems to point towards, it says right here, the zoning ordinance appears to allow most agricultural and forestry uses by right in the agricultural district. And then you go on to enumerate 2, which is that recommend that the county attorney review uses such as aquaculture and the distillation of alcohol, ethanol, for farm use for compliance with state code.
Where again?
Sorry, this is on page 15,
Page 15.
at the bottom there.
And row number
64.
15,
Yep,
1-5.
64, row number 64.
Bingo.
Sorry, guys, I just sort of
No problem.
charged ahead there. It is noted that these uses are not defined in the ordinance, and Rappahannock should consider defining each use. And so I'm thinking to myself, I wanted to ask you specifically why you brought up those 2 examples, and if there are other examples that you can think of off the top of your head. And the second question is that do you know offhand if the distillation of alcohol, meaning a distillery, is considered an agricultural practice in Virginia?
If it's a
without-
farm distillery.
If it's a farm distillery, meaning in the other recommendation in Appendix A about limited farm distilleries. Is that what you're referring to?
Yes.
Okay.
That's the answer to your second question. And then I said I would answer your first question to my best of my ability. I'm going to turn it over to my coworker. That's the best of my ability. That's
Very well done.
that is a very obscure piece of state code, and she is much more of an expert on state code than I am.
So the reason why we pulled out those is when we were looking, we looked at your use list and the ones that are in agriculture, and we said, okay, some of these are requiring a special use permit, and they're listed in agriculture. So that's, to me, red flag.
Right.
Because that state code says if it's agricultural use in an ag zone, you can't require a special use permit. So.
And the organization of our ordinance is such, in that use table, we have different sections, or whether it's residential, commercial, and then there is a section agricultural, and then there's uses in that require SP, so that is this kind of.
Right, but I'm not an attorney, and so I won't make a judgment on if that is legal for your ordinance, if you're completely in compliance with that state code or not, and so that's why we say, talk to your county attorney and just make sure you are in compliance with those items.
Mm-hmm.
Well, but a farm winery or brewery where they are producing something for human consumption wouldn't be considered ethanol for farm use, would it?
That, I thought you had another use listed related directly to that.
know if we've ever actually made that distinction.
Distillation of industrial alcohol for farm use is provided as its own use. It's not farm winery, it's not brewery, so that to us was like, what is this maybe? But there's no definition, and so that's why it's important to have definitions about it.
Well, it doesn't count if the use is in the ordinance and we don't ever use it, so. Does it? Okay.
They're just red herrings.
Yeah, absolutely. And that's where the court case really got
Yeah, there it is.
my alarms went off, because there were things that the judge was asking that we thought was clear for us, but obviously she did not. And I'd like to go into a court case and win, knowing that we're gonna win, and get all of this organized in a way that is very clear, so
Yeah.
we don't
It's
have
kind of
to.
like the New England Patriots, you have to pay for the referees.
Or flatten the ball on them.
And this conversation brings back another recommendation of theirs, and one that Ms. Summers, myself, and Mr. Goff have run against a number of times. Of all the uses in your use table in 7036, very few are actually defined in your zoning ordinance.
Right.
Bad plan.
Yeah. You want broad uses, clear definitions.
Yeah.
Yes.
Otherwise, we're left, zoning administrator is left to define what it means based on the available definitions that are there or the dictionary.
That could change with zoning administrators or.
And then it's, if somebody appeals that, then it's subject to the court-appointed BZA or a judge. And so if the board, the community, through the board, has a feeling of what uses are appropriate in the community, then we should clearly define what they are, so that it's plain language and there's no confusion of, is it a kennel, or is it a this, or is it a that? And we've seen that here recently, having to parse these somewhat obtuse definitions where we have them, or go to the dictionary and say, well, this is what a distillation of industrial alcohol, ethanol for farm use.
But couldn't you just take care of that with a cover phrase as subject to the definition in the Code of Virginia 1950 as amended?
But it's not there either. You know, there's no definition in the
Let's
state
throw it
code.
back on the state, they make more money than we do.
So that is, I've found many of these, and some are maybe obvious. Swine farm greater than 20 sows. I guess maybe you don't have to define that. but-
You would think things are obvious, but you can ask any zoning official, they'll tell you that you can interpret something a number of ways, no matter what. Oh, this definition has an or in it instead of a shall, or
Yep.
something like, it's something as small as that can lead you down a rabbit hole of interpretation and definition.
Sure, shall is it's required and or is open to
That was just a
discretion.
random definition,
Well,
sorry, or
it's
example.
discretionary.
But yeah.
Well, and then it's the order of commas, and is it an Oxford
Sure,
comma or not?
yeah,
Is this
yeah.
you know, and
Yeah.
and so then we get to the county attorney, and he helps us make an interpretation, and it might get appealed, and the BZA may have a view on it, they might not. That might get appealed, and eventually a court is gonna make a decision, when really those decisions should be made by the board through clear wording in the ordinance.
We use view shed a lot, but it seems that the judges don't necessarily know what we mean by view shed either.
Which
So-
means if you have certain use regulations built into your ordinance that might affect view shed benefits, but are more objectively applied, then you can get the end without having the subjective, consideration.
Sure.
That's what I'm hoping for, but I knew that the planning commission was not going to be able to do this all on their own, so I'm very glad that you were brought in.
Yeah, we are happy to be a part of this process and happy to help you guys in any way, shape, or form that we can. Rappahannock County, as I said in my opening statement, it's beautiful up here, and we want to help you keep it that way.
Thank you. Thank you, yeah, thank you for doing this. I think it's incredible the appendixes that you've set up are really comprehensive and very easy to read and to navigate, so thank you guys. At least for me, going through it and then saying, hey, where are we just out of compliance, which was the thing that I really wanted to see.
Sure.
It was really easy to see and then reference it, so.
Good. Thank
Just
you.
stay
And,
good, so-
and like I said, we're available for any questions that you might have down the line.
How do you feel about maps?
Love maps.
That was a trick question.
I think we talked, some of this in our earlier conversations when the comprehensive plan was being updated and whether future land use plan is in the comprehensive plan. It's a narrative plan.
Sure.
There is no future land use map. Should there be? And so then the village areas, as was brought up earlier, there's narrative definition of what that means. And there's pros and cons, and we talked to Darren about that back when he helped us with the comprehensive plan. And it was there's different ways to look at this. There might be a place for the next time we're looking, or as we're looking at the comprehensive plan and continuous improvement, that we begin to look at village area plans, narrative, possibly with maps. I don't know, but the community needs to, provide their input to the board and the board direction to staff. Is that what we want to do? There are pros and cons to those approaches.
Yeah, and I think this, kind of lesson learned last time, we should definitely engage a third party such as y'all next time we take it up.
Absolutely.
I'm sure there was rigorous public input to the extent that you can have it during COVID. But, we kind of didn't have a lot of buy-in toward the end.
And mapping support is definitely something that we can and do all the time. But since Darren is my boss, whatever recommendation he gave you, that's my recommendation. So we'll go with that one.
Very diplomatic.
Yeah.
And tell I've worked in government for too long.
One of the things we also talked about is, our zoning maps, they need work.
We don't have zoning.
And so that is something that the board has provided some funding for. Whenever we get done with the 911 updated mapping, then we'll start working on some of that to improve those maps. And that'll be a pretty involved process because Madison went through this a few years ago. And, we go from these pencil crayon maps that you put two next to each other and the lines just are like this, right? So that means we're pretty much going to have to go through public hearings to re-adopt the zoning map once it's all stitched together.
Well, I think it's just another one of the steps we've got to get through if we want things to hold water.
Yeah, I agree. And then once you do that, then all of a sudden you can see the zoning map as a whole. Like the whole county, like, oh yeah, look, it is more dense around these village areas. We're already doing it. But right now you look at it in a way that you can't really see it.
Yeah.
Madam Chairman, I wonder if we should hear from the Vice Chairman of the Planning Commission and see if there's anything we can do to help inform their way forward or any additional input from the Planning Commission
Happy,
perspective.
Mr. Lade, if you want to say anything. I know we sat in on your meeting, or Mr. Carney and I did, so we got to listen to what was brought up. But I'm just, again, the thought is, in what order, how do you construct this so it's not like the comprehensive plan in my mind that took forever because it was so big? How do we make this manageable for the people we have and for the Berkley Group?
Yeah, there's a lot to digest, and we're a little bit ahead of you in having had this a little longer, but many of the same questions have arisen. It was brought up before, what is the order of priorities? We've been working on the sign ordinance. That's been a slow slog. I think we have a work session this Tuesday where we're planning to kind of regroup with our two new members and reconfiguration and try to establish how we're going to approach this. But one of the questions that came up in our last meeting is, what is the right word? Because, for instance, seeing the list of things that are listed as non-compliant, having looked at those, most of them are fairly straightforward fixes. It's either 45 days should be 30 days. The code reference should be to a different section. They're hardly controversial, and yet it could prove the legal aspect. That would be a very different course, though, than I think the natural one we are on, which is going segment by segment, topic by topic, signs, solar, events, etc. Those are two very different approaches, and if you have guidance for us as to your wishes, I think that would be valued by the commission. I will say, some of the discussion came up earlier about or what is the Berkley Group's, professional opinion based on best practices and what's done elsewhere, I would caution that there is a lot of policy implications in that, because their view of these things is based on what has been done elsewhere and what is kind of the best practice across the state. And I think it is something that should be looked at with a long-term view. If we start down this path of totally changing our uses and trying to define them, that is a very comprehensive exercise. I mean, the planning commission spend hours just going through the definitions associated with signs. And it's very hard, and they're extremely important. And really, there's probably nothing more important than those definitions. And as already been discussed, very many of our very critical terms are not defined. So, what we have done historically is a very incremental approach where we've kind of evolved, and we've got a lot of kind of the way we do it sort of things that seem to be reaching the limit of their feasibility and bringing us, I think, increasingly vulnerable to some legal challenges. But to pivot from that to a total rewrite and to structure it differently, that's a very big lift. And I value, and I think we could work very well with the Berkley Group. I would recommend that we look at what that long-term prospect is, because not only is it a matter of changing these regulations, it's a matter of then having the staff to implement them and carry them out in that way. And I would just say, for many of these things, there are reasons why Rappahannock has been different in the way they've approached them. And I wouldn't want to abandon all those things just because that's not the way it's commonly done. So I do think it's with careful consideration in those ways. Those are my initial thoughts.
Could I ask a question or make a comment or two based on something you just said? You said you spent several hours on the definition of signs?
The definitions associated with signs, yes.
That I don't understand. Having been in the sign installation business and then sitting on the planning commission for a number of years, this Reed versus Gilbert basically put signs in the concept of a sign. I think the Norfolk case is a sign, by definition now, is something that directs an individual's attention to a noun. So if you will, a person, place, or a thing. If it doesn't do that, it's not necessarily a sign. So.
But then there was all the different types of signs, whether it's a pole sign or
Well, but that doesn't,
sign.
I mean, those are
But
already
those are
defined.
definitions that were,
But we already have those definitions, and those are standard definitions across a broad spectrum of this country.
but they weren't, and a lot of the definitions that we had would be thrown out because they weren't. You had to read the sign to interpret the definition, and so it was harder than you might have guessed. But that might be on video. You can watch that excitement.
Popcorn.
I mean, there's no way I'm gonna understand that it took several hours to discuss that, because a pole sign is a pole sign. You have to regulate the height maybe. Because we certainly don't want a pole sign in this county that's 85 feet high, because I ain't going up there to work on it, number one. I want it down low. If I'm gonna work on it, I want it pretty low now. The older I get, the lower that sign has to be for me to be interested. But, so you have pole signs, you have heights, you have monument signs. All those things are clearly defined in other jurisdictions. I don't know why we have to spend hours discussing something.
That's how we do it here.
Yeah, I understand, but that is the type of thing that got the planning commission hung up, and it didn't make much progress on a variety of issues for a long time.
Well, I encourage you to come to our next meeting and maybe give us that guidance if that's your view. I know there were a lot of terms that were not defined in standard ways, and the various types of signs. I don't know where they originated. Perhaps it was
Fairfax property.
I mean, I could have, if somebody had to, I tried to work with a former planning commission member, but he never had any discussions with me on this. I could have certainly lent some, effort to it.
And it's tough to come to a meeting, and if three of us are there, then can't say it, the one that's involved in the meeting should speak. And the other two of us should probably hold our peace because it's really not fair to each other. So it makes it
Yeah,
hard to have a
right, we've already got a member on the planning commission.
conversation.
Well, the sign ordinance will definitely be before you in the future, and the work is progressing at the planning commission. There's about the back half of that ordinance needs to be scrubbed based on what staff, county attorney, myself, and Ms. Summers have developed and shared with the planning commission, went back and then modified, and that's what's being kind of tweaked, fine-lined right now. And I think once that's done, then this board might think about, do we screen that back through the Berkley Group, or how do we want to do that next step before we go to a public hearing? And that's one of the things we talked about at the planning commission is, the planning commission has no interest in putting something forward to the board that's dead on arrival.
Right.
And scheduling a public hearing on an ordinance that kind of fixes that ordinance before it goes to the board of supervisors that's dead on arrival. So there's got to be some kind of, you have to coalesce on what you want to get the public input on before you get public input. So it is a process.
Yeah, joint meetings are always good too. Well, for my 2 cents, I mean, we adopted the comp plan in 2020 in December, so 2026 we're due to pick it up and really look at it again. Seems like there's a lot of material here for a big lift. I don't know if you all think that's worthwhile. I do think the list of things we've referred to the planning commission is a good list of things that are a priority for us as a board. Otherwise, they wouldn't be on the list. And I am very reluctant to take up noise and lighting. I think that's a bad idea. That's my 2 cents. If the majority of the board thinks otherwise, so be it.
And we did share that noise was brought up before my time, but
Not that long ago.
but it was considered and put back away. A full dark sky ordinance, I think, was brought up and kind of packed back away. But I think Culpeper has some specific ordinances relative to dark sky that we looked at relative to Cleverson's Corner, that when you do have a special use permit or special exception, then you can grab that standard and say, meet that. If you want to have this extra special use that's not normally allowed in this zoning district, no problem, meet the standard.
We kind of do that now, but it's an add-on at each
It is.
event, so if you made it a standing
I think
general
it's
condition.
then it provides more security for you along the way, saying, wait a minute, you're treating me different than everybody else that ever got this kind of permit? You say,
No,
"Well,
you're
just
right. Make
So
it,
I'm wondering if, I know we're unique, and I absolutely love Rappahannock County, but are there other counties, kind of sort of size-wise, rural Virginia, that are going through something similar? And I'm wondering if you've given them a recommendation on how to tackle this, because it does look huge, and if we can't figure out how to have boxes to work on, I think it gets overwhelming and you just don't even move.
Sure. The Rappahannock County is unique. Rappahannock County is not unique in all the problems that it's facing. We are seeing a lot of the same problems of how do we maintain this rural character with this overwhelming supportive development coming out of kind of the craziness that we've seen in the last couple of years, and all these other mounting pressures that we want to try and deal with. As far as tackling those issues, my official recommendation is, and always will be, try and do as much as you can all at once. It makes it easier, and it makes it more consistent and more clear. When you piecemeal together an ordinance, that's when you start running into these issues of, well, this article in the ordinance says this thing, but this article in the ordinance says completely different, and they're talking about the same thing, and it's very confusing, and I don't know what to do. And then you run into the kind of the same organizational issues that we're recommending that you fix now. So that's going to be my recommendation for you. I understand it's difficult and it's tough, and it takes funding, and it takes staff to do those things. What is that? Or Berkley Group, right?
Yeah, y'all are great, and just to revisit the comp plan. I mean, 2019 we sort of went through some different exercises with it, and that's at which point we engaged y'all because we felt like we still didn't have everything exactly how we wanted it to be. Darren in particular helped us figure out what we needed to do to get in compliance with the Code of Virginia.
Sure.
And some super helpful, but I don't want to say easy, but it definitely pointed our work in the right direction, which was invaluable.
Good.
So at that point, it only really took us a year to get through to where we could adopt it at the end of 2020, which was great. So I mean, I think we should establish priorities and a work plan and get it done before the next comp plan revision. And it's a rare opportunity that we have the time and talent and money to get it done. And it's the pivotal work that needs to get done to protect our beautiful county.
I'll add, if you're curious about our process and how we do the ordinance updates, we do recommend doing kind of the full suite, because as you said, if you get in and you start changing a use matrix, then it's, okay, well, wait a minute, you're now renaming this use, so that affects how it's listed here in the use standards, so we need to do that here. And then, well, we also, realize in this district, the size for the acreage is this, and so you end up kind of needing to touch a lot of things at once anyway. And as has been done in the past, you try to fit it in here or try to fit this here, and then it just doesn't work for good organization for a whole document later. Our process we have done in many localities now is feeling really good, feeling really smooth. We start out with some easy things, kind of looking at, okay, administration. What are the duties of the zoning administrator, planning commission, board of zoning appeals? Getting those process things done. What are the permits that are required? Getting those things done. And then moving into, okay, let's discuss the district standards. Let's discuss the uses. And along the way, we're adding in and placing the definitions with each topic that we're talking about. In this process, depending on how quickly the planning commission moves and how many meetings that we need to schedule on each topic, each portion of the ordinance, you can have the full ordinance ready to go up for public hearing and adoption in a year and a half, I would say, maybe a little longer. Some go 2 years, just depending on, how much you want to add and the topics, how tough they are sometimes. Planning commissions do get bogged down. We do, you mentioned joint work sessions. We do recommend that so that you are, all talking together and you know what's coming to you and you're not surprised at the 2-year mark of what's there and we have to, redo things. But that's the process that we like to. We will search around the state for other, localities that are similar to you, or ones that we think maybe have similar issues on a particular topic. We'll bring forward draft documents for you to review. You give us the feedback. We change those, we strike those. If you say, no, this really isn't Rappahannock, we think this number should be 200 instead of 300, we do that, we make those changes, and then we move on to the next section and continue the process.
And to Mr. Light's point, if there are things that are in your ordinance that are working or are specific to Rappahannock County, that's just going to make our process of incorporating those into the newer ordinance much faster. So that will speed things up.
Yeah, you say, don't touch this, we like it. And you say, okay, easy, copy paste.
Leave lighting alone. We'll leave it alone.
Every 14th word is perfect.
And I assume you have a zoning attorney on your team that takes a look at what we're.
So we have a sub-consultant that we can pair with if you want those services. That would be an add-on service. Otherwise, you can, just send it to your county attorney.
Planning and zoning is more of a specialty, I think, and the county attorney unfortunately has to be a generalist.
Yeah.
And a very wide variety of issues.
We use, the name is escaping me at the moment.
Sans Anderson.
Sans Anderson, we've also used Pendec.
Okay. Sharon Pandek works with this board on a few different things.
Yep.
Yeah. So, yeah, if you want to add those services, we can do that.
So I have heard from some that it is such a specialty that having someone in the room when something's being written adds so much value, so you're not going back and having to redo it anyway because the attorney that finally does see it says, no, that's not gonna work.
Looking at me.
Next steps?
Well, like I said before, the board did appropriate a fair amount of funding to have the planning commission be able, in the planning commission budget, to allow the planning commission to try to advance this. That was after the funding that was in last year that afforded the development of this report. And so the goal is to build on what you've done. The board, of course, is well aware you have a healthy fund balance to take care of one-time expenses. And so, you know, this is the sort of thing that is a one-time expense, as Supervisor Smith said earlier. Doesn't make sense to bring out a bunch of staff to try to crank through this with a recurring cost and then say, okay, thanks, you're laid off. And so, you know, my view in most things is let's do it and do it right best we can. Now, trying to make sure we're always looking through the Rappahannock lens is the critical thing, and the unforeseen consequences, we do our best to try to kind of pull back that veil all along the way, because there isn't any other community like Rappahannock that I'm aware of in Virginia that is, every other locality has an interest in growth, period.
The state does.
And that is generally the nature of localities. And it may be very finely targeted growth, where I think we have a different perspective on sustaining what is here. So that is a totally different scenario. So we have to be looking at
Can
that.
I comment on that, because one of the areas that I think exemplifies this, and I would encourage you all to think about, because it's one of the ones that struck me most loudly, is this idea of the cluster development and the fact that if you really sort of digest our regulation, yeah, we kind of allow it to some degree if somebody really figures it out. And what they're saying, which I think is accurate, is it's really kind of hard and you're not really encouraging cluster development. I would kind of argue that that's a little bit, at least by design, and some of what they're recommending to make it clear and perhaps more incentivized, to me, goes a little beyond what I feel has been the sentiment.
Might cause it to actually happen.
Exactly, and so I think this is where, you know, there is, that one in particular, and there were a few others, that, you know, some of the stuff just seemed like the discussion about wind and different hydro. Yeah, it's not in there, but it's not in there because we've never had to face it, and okay, yes, it should be in there, but it hasn't been operational. Some of these others, like the clustering, and, you know, of course, we've struggled a lot with village boundaries already. We know how, you know, challenged that is. There are a few, I think, among these that are more significant questions in addition to the noise and lighting that's already been discussed.
I would agree with that completely. The cluster housing to me is something I think we're going to want to see a lot more about before we make any decisions.
Well, the zoning ordinance allows it, but it's not exactly
Kind of,
spelled out.
right.
I mean,
It's-
the problem is you've had a lot of real estate people giving out misinformation that we have a 25-acre lot size requirement instead of a 25-acre density. And instead of somebody taking a 100-acre parcel and cutting off 3 small lots between 2 and 5 acres and selling those and retaining the 75 acres or 85 acres for farming, we get 3, and I've said this before,
425.
we get 4 25 average acre lots, and it only benefits the realtors, the bankers, and the guy that sells compact tractors.
That's right. And in some
Nobody
ways,
else.
3 2-acre parcels with the remainder of 96, 7, 4, whatever. 94.
Right number is yours.
94. That is clustering to some extent, but in the classical cluster is you end up with a remainder parcel that it maybe is dedicated to the public and is then can't be touched period forever for any use, which we kind of allow, and if it's in the floodplain, and then, but if it's not something we want to do, which encourages small lots in a subdivision, then take it out.
I guess my point in raising that one is, when we talk about these things, is it there or isn't it there? Is it compliant, is it not compliant? These areas have a lot of shades within them, and that one in particular, I think we can all kind of relate to because of the discussions.
Yeah, the whole density conversation is extremely confusing for staff as you talk about the density, how many structures can go on this parcel, does it depend on what the parent parcel was? And if I put an extra structure on my parcel, does that take away your right next door to have a structure?
We don't have any limitations on structures on a parcel, do we?
You have a density. So if we had that 100 acres, how many structures can go on that? 4?
You talking structures or dwellings?
Maybe either.
Well, a structure is not a dwelling. If you have a dwelling density of 1 per 25 acres, then you could have one dwelling and 16 sheds.
That's true right now, that's a different topic, but, so if you get a permit for a second dwelling on a lot or parcel, does your neighbor now not allowed to have a building, a dwelling?
It shouldn't affect them.
It was started out as 100 acres, now you got 5 dwellings, is that allowed?
How many divisions and all that stuff?
Well, I mean, if it's 1 per 25, and now you got 5 dwellings.
1 per 25, well, that's already taken up, it would be 4.
So you've got 2, your
Unless-
neighbors each have 1, and then the fourth guy's just out of luck.
No, each lot of record would be able to have a dwelling on it. If it's not a buildable lot, then it's not,
I would say
They have
that's
a dwelling.
not clear at all in our ordinance.
it never was until recently. Why is that?
The words in the book. I don't know, maybe you didn't read them before.
Can I comment on this, because this is an example of something else I think we deal with, which is those of us who've been, especially Mr. Fraser and others who've been dealing with this for a long time, there is, these things are dealt with in there, but when you walk up to it and read it, especially even with the professional lens that the Berkley Group does, it's not in the form that they're accustomed to seeing it. I think that is true for anybody who walks up to this.
I agree.
There's a lot of required history of the evolution in order to understand it, and that is the natural consequence of this being kind of incrementally tweaked over the years. So to that extent, I certainly agree with the recommendation that if you're gonna rip this thing open, you might as well really do it. Especially if you're talking about the use definitions, and I also really agree with the point that once you're those are all the kind of paths into this regulation. Once you start moving the doors around, you gotta remodel the whole rest of the house. And so I think, I don't agree with everything in that document, but those are, I think, very compelling points that I would certainly agree with.
So I guess to wrap up my thoughts, I know the Planning Commission has a lot on their plate, but unless there's specific direction from the board, then that body should be empowered to look at these recommendations and then recommend back to you how they think the community should move forward on these topics, on affecting some of the corrective actions that are suggested here, which ones might be important or not. And so either the board needs to push that down, or you need to ask them to give you a recommendation.
I believe at this point, we saw the phrase used a couple of times, a kickoff meeting. I think we need to have a joint meeting with the Planning Commission for a kickoff meeting, and I think August is a good time to do it. School will be back in session. It's all fresh in our minds. We're looking at it. I think now's the time to do it. Just have a kickoff meeting so that we don't start getting divergent lines, 2-3 months down the road. We start as close as possible together so that we're working in the same direction.
That is a good way to get everybody around the table.
I mean, obviously, sometimes you may have to come back around like that because of all these discussions that have happened. But I think the sooner we can start in the same direction, the closer we'll wind up later on.
would it make sense to try to have a meeting that at least one of the Berkeley folks could attend, or do you want to?
Well, yeah, I think that would be good, and our county attorney should certainly be there, because he is our county attorney, but I just think that it would be good to have a kickoff meeting, and if the regular date of August doesn't jive with yours, maybe we can have you here by Zoom, or we could have you here, just move the date a week or something.
Regular, you mean planning commission date?
Maybe we would have a separate meeting for that.
And I don't know what's on their,
Agenda.
what's coming up, if it's gonna be a busy meeting for the regular meeting.
No.
No.
And that's the 17th. 16th.
I mean, if you have a full agenda, then maybe we could do it a different day. But we've got to get the notices, and we only need basically 3 days for
Well, I
that.
would certainly support that, because my intention is to leave town on the 18th.
It's not gonna be that bad, Gary.
Coincidentally, if we could do it, then, and again, I mean, this will be helpful, we do have this continuation of our meeting this Tuesday, but based on this conversation, I think I would update the commission on this discussion and turn our attention back to the sign ordinance, which I think is still in need of our attention.
Are there any specific areas that maybe you could send me some information on, and I could?
Well, you can have, the draft is, I think, posted on board docs and.
Well, I'm looking at it here, but I don't see anything that would have taken 3 hours, so I don't know. I'd really hate to watch 3 hours of that video.
Well, if there were 13 planning commissioners, it would have taken 4 hours, so just be glad that you only have 7.
I know that it wasn't on the agenda, but if everybody on the board, if we get to a point where we've all kind of said our piece, do you think we should hear from the public and see if there's any public questions that maybe we should answer tonight? And that's part of our comprehensive plan, is encouraging public
I
involvement.
think, technically, you're maybe not allowed to do that because it's a
She
special
asked
call
for it.
meeting and you're not all here.
We've already had people speaking out of turn in the audience.
Well, you've asked
we
the planning
asked
commission I'm just telling you what the state code says.
Yeah.
But you can do whatever you want.
I choose to
Alright,
follow
then.
state code.
And I can actually bring it up this week.
And we will, basically, you're going to look for a date that will work for the board, planning commission, and
Well, it sounded like, I'm sorry, I just there's that question.
I would say at this point, we have finished our kind of agreement and scope of work that we have at this point. But if you want to reach out to my supervisor, Kelly Davis, and, say that you would like involvement in, further discussions, then she can talk with you and let you know if one of us can attend.
even if you're by Zoom or something, we can
Right.
set that up.
And to be fair, I know that they've already told me they're stacking up with work. So if we want them involved, we need to get in line.
All right. Anything else from this? You're good with where we are right now? We basically have to get back with you, it sounds like.
Absolutely, yeah. We'd be happy to lend any additional support that you'd like, but yeah, let's just reach out to our further up the chain.
Okay. Thank you very much for being here tonight. and-
Thank you very much for having us. We really appreciate it.
Thanks, Chris and Rebecca.
Thank you.
Thank
So
you.
tonight you gather that there is an interest for a joint meeting on the 17th.
Yes,
Yes, please.
yes, please.
Okay,
Motion to adjourn?
Second.
Always in order.
we have a motion and a second. All those in favor say aye.
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 Except